No context. All right. Consideration of an appeal of the Planning Commission's decision to deny an appeal regarding an administrative decision of the preliminary application for 11511 Summit Wood Road. Do we have a presentation?
Yes.
Okay.
Yeah. Good evening, Mayor and Council. So yes, as you already mentioned, this is an appeal of the Planning Commission's decision. It's a very narrow scope. We are really focusing on a date. There are 2 proposed development projects at this address. However, we're not talking about the projects themselves. We're only talking about when staff accepted the applications as being submitted in a complete form. And we have a disagreement between staff and the applicant on that. So you can change the slide, please, Cody. Just for reference, here's the property. It's on Summit Wood Road, which is accessed off of La Loma. Next slide. There's a aerial view. You can see it's a very wooded area. Next slide. So for some background, the application was, we had 2 preliminary applications come in on February 2nd. The town responded to those within 30 days, and so the response letter was sent to the applicant on March 3rd. The applicant resubmitted, and that happened in early April. And then the town responded to that second submittal on April 21st. As part of the comments on those first 2 submittals, staff requested an application form because no application form was submitted. And these are SP 330 projects. So the State Department of Housing and Community Development, HCD, created an application specifically for this type of application. So rather than reinvent the wheel and come up with a whole new application, the town just adopted the state HCD application form. So that's what we asked the applicant to submit. And ultimately, the application was submitted to us in early May. And then at that time, it came to light that there was another property owner. We didn't have all the information. When we realized there was a second property owner, staff asked that the second property owner sign the owner's affidavit as part of this application. And then that came in on June 2nd. And at that point, staff accepted the applications as of June 2nd, 2023. Next slide. And so what happened was that was an administrative staff level determination. The applicant appealed that to the Planning Commission. Then the Planning Commission considered that. They upheld the decision, denied the appeal. And subsequently, that was appealed to the council, and that's why we're here this evening. So the applicant, who is also the appellant, believes that the Planning Commission erred, states that an application form isn't required. And also he pointed out that his wife is a minority property owner and he does have a power of attorney. That wasn't something that came to light until we were at the stage where we had the appeal filed. So that wasn't even a known quantity until very late in the game. So the application form, whether or not it's the HCD form or the town form, we need some sort of application form. And the language says may use the HCD form. If it's not that form, it should be another form. I've never seen an application filed without some kind of application form. So we're basically, that's our narrow scope. We're in disagreement on when the applications were considered submitted. Is it May 5th? Is it June 2nd? And ultimately, can you change the slide, please, Cody? So again, staff used the SP 330 application because it's very specific to this type of project and has all the required elements. So it made a lot of sense to use that particular form. So that's where we're at. And ultimately, staff is recommending, let me talk about public noticing. Next slide. This particular hearing was notified notice was sent to owners within 500 feet. That happened on the 15th of September. Posted in the town posting locations. That happened twice. That got posted on the 8th and the 15th. And then there's a site card that's put out on the property, as well as the agenda and all the documentation being posted on the town website, which happened last Friday. This says staff received one public comment. That we actually received a second letter very late this afternoon. So you should have two supplemental items. One is from Cal HDF and one is from NIMBY. Next slide, please. And so staff is recommending that you deny the appeal, uphold the planning commission's decision, and subsequently the administrative determination that the application was submitted. They have two applications were submitted on June 2nd. We have prepared two resolutions for the council, one that would deny the appeal and has extended findings in support of that denial. If the council does decide to grant the appeal, we have prepared a resolution for that. However, we would need to come back with findings that, if that's your direction. And that concludes my presentation. So if you have any questions, I'm available. And we also have the city attorney and assistant city attorney available on Zoom as well, if you have any legal questions.
We have any questions or should, oh, go ahead.
With respect to the power of attorney, was the power of attorney presented at the time of the application?
No, it was something that the owner informed us about after he filed the appeal to the planning commission. As part of his argument, he was saying, I have power of attorney from my wife. She shouldn't have had to sign the application. However, all property owners are supposed to sign the owner's affidavit. So,
We have a copy
yeah,
of
we
that
didn't.
power of attorney?
So at the time we asked for the second property owner's signature, we weren't aware of a power of attorney. We were informed of that after the appeal was filed to the planning commission.
With respect to the power of attorney, was it specific to the property itself? Was it a general power of attorney? Was it a general durable power of attorney? Was it a springing power of attorney? Do you have a copy of the power of attorney?
Yeah, I don't know the particulars. Steve might be able to answer that, or we also have the applicant present.
Yeah, I can respond to that. The power of attorney was submitted during the appeal process. It was never submitted during the time period that the application was actually being considered by the town. The power of attorney it appears to be a durable uniform power of attorney form. It is related to real estate interests only. It may not, the form of it may not comply with requirements of California law, and the person signing the power of attorney executed it back, it appears, in 2019. And yet it wasn't notarized until July 29th of this year. And so there is some question as to whether it's actually even valid for the purposes that it's being used for right now. And the most relevant point that we would bring to the council's attention is that even if the power of attorney is valid, it wasn't submitted in a timely basis along with the applications, as is required under HCD's, the HCD standard form, which clearly states that if there's more than one owner of the property, that the documents need to be executed on by both property owners. So in this case, both the husband and wife who own the property themselves. And so So from our standpoint, and this is an issue that came up in a number of the comment letters that were submitted to the town today, we don't believe that even if you accept that the power of attorney is a valid power of attorney, that it was timely submitted.
Okay, so I heard July. I heard July this year was when it was notarized. Is that correct?
That's correct.
Okay, and the submission was previous to the July timeframe, is that correct?
No, the submission of the power of attorney was after the June 2nd date. And so the submission of the power of attorney was actually done as part of the appeal process for the planning commission. So the staff determination was actually made in early June, if you will, and then the applicant notified of it on June 2nd, as I recall. But the power of attorney wasn't actually submitted until the matter was on appeal before the planning commission, which was later.
Okay, with respect to the notarization of the power of attorney, did you say that that was in July, Steve? July of this year?
Yeah, it was notarized on July 29th of 2023, but the document itself was signed originally by the second party with a date of 2019. So there's not a contemporary notarization of the document at the time that it would have been executed by the second party.
Okay, so there is a possibility that it's not valid for the signature as of the date of the application, correct?
There is that possibility. We're not determining that ourselves. That would frankly require court determination to determine its actual ultimate validity, but it is not consistent with the way that notarizations are supposed to occur. And in terms of making the power of attorney effective, we believe it would not have been effective prior to the June 2nd date, which is the date that's really the subject of this appeal.
Thank you.
All right, thank you. Any other questions? Should we hear from the,
Yes, Mr. City Attorney, does the council have leeway to give more time to the applicant to speak, or how does that work?
The council can identify whatever time the council deems appropriate for the appellant to speak in this circumstance.
okay, so how much time do you need? How much? Okay. It's late, so shorter is better, but hey, you got 10.
Schedule said 7 o'clock. Here we are.
I know.
Hi, I'm Sasha Zbrozek. My wife and I own 11511 Summitwood Road, and I'm appealing to the council to follow the state law. Back in February, I submitted a pair of applications for multifamily housing leveraging provisions of California law, section 65941.1. That statute enumerates a short and simple list of requirements for a complete application and vests the right to ignore zoning and pursue the project. It does not require an application form of any variety. The town didn't accept the application, claiming that I needed to include additional paperwork that was not part of the list. Despite not needing to do so, I revised the application multiple times to try and accommodate the town's requests. Through a combination of strategic heel dragging and drip feeding of claimed shortcomings, the town delayed admitting a complete application until June 2, after HCD's determination of compliance of the draft housing element. I appealed to the Planning Commission, paying a fee required by municipal code, as well as a deposit which is not. During the discussion for the appeal, commissioners considered their feelings and procedural traditions, but did not consider the text of the law nor the precedent of its interpretation. That's not how governing works. And I'm not here asking the council, and I'm here asking the council to take the law seriously and overturn the Planning Commission's denial. What was all the paperwork fuss about anyway? Staff and the commission, advised by a town attorney who has an unfortunate track record of misinterpreting state law, felt that my wife needed to sign an affidavit form as part of an application. State law plainly does not require an affidavit from anyone. It does require permission from the owner of the property if and only if the applicant does not own the property. But I do own the property, and the law does not prescribe that a partial owner must obtain consent from all owners. Besides, the intent of the law is obvious. The applicant needs to have authority to make improvements to the property, and I satisfy that intent twofold. First, black letter property law governing tenancies in common allows any individual owner to make improvements to the property. Second, I have power of attorney over my wife's share, so I can unilaterally make decisions regarding the whole property. As such, I made good both by the letter of the law and the spirit of the law. There clearly was no need for me to further provide consent from all owners of the property independently. Regarding the notarization, we had signed all of our paperwork at the time that we bought our house, put the thing in the drawer, and did not notice that there was a slot for a notarization at the back of the first page until we actually dug it back out to scan as part of the appeal. So we got it notarized at that time. I don't need to go again into the specific clauses of the law unless a council member is interested and asks today. I read the relevant section of law into the record during my appeal, and my attorneys also sent a letter on the matter and clarified the myriad ways that the town is obviously and malignantly misapplying this and other parts of state housing law. I'd also like both of my deposits back. I never agreed to their expenditure, as they are not required by municipal code to submit an appeal, but planning staff refused to accept my appeal paperwork without that extra legal lubrication. And finally, I would like to remind the council that they still have not actually adopted a compliant housing element into the general plan. While the draft has been accepted as compliant by HCD, council needs to formally adopt it. Council granted authority to staff to modify the draft to reach compliance, but it cannot delegate its authority to change the general plan. The town is still vulnerable to further applications under 65-941.1, including resubmissions of this pair of projects. Thank you.
Thank you, Sasha. All right, so what do? We talk about it, and I've never gone through one of these, so.
Yeah, Madam Mayor, if I can address the council, the council should take all public testimony and then close the public hearing. And then if the council has any further questions before you deliberate on it, you can address those to staff, or if there are even questions for the applicant, you can address questions back to the applicant. And then the council can make a determination. Staff has provided two resolutions for council consideration. One is to affirm the Planning Commission's determination to uphold the staff determination. In other words, the determination that the application was not did not satisfy all the other submittal requirements by June 2nd until it was actually determined to have complied with it, which I believe was on June 15th. Or alternatively, the council can grant the appeal, and then if the council does that, then staff would request that the council direct us to come back with findings in support of that resolution. There's two resolutions in the packet, one denying the appeal, one granting the appeal.
All right, thank you. So are there any more public comments?
If you could open the public hearing and then call for public comment, please. Thank you.
All right, are there any public comments? Anybody online?
There are a number of people online, but nobody has their hand raised currently, Madam Mayor.
Okay. All right, I will close the public comments then, and we'll discuss which of the resolutions we want to adopt or to send. Lisa?
Madam Mayor, if I may address the council on one issue.
Sure.
The town did receive a couple of letters today from various interest groups that were in support of the appeal that Sasha is bringing forward this evening to the council. And if the council would like us to respond to those letters, we're prepared to do that. We do believe that the staff reports do contain the basic underlying information. And so that information is already in the record, but if the council wants us to kind of briefly go over each of the letters and provide our responses, Claire and I are happy to do that for the council.
Do you want that?
That was actually my question that I was going to ask. So
Yeah, I think
yeah, I
that's
would
what
like that.
think.
Yeah.
So yes, could you go ahead and respond to those two letters?
Sure. If the council will give me just 1 second here. So One of the two letters was submitted by Yimby Law, and they made a series of arguments. The arguments in both letters were fairly similar, but Yimby Law made 5 arguments. The first argument that they made was that Government Code Section 65941.1 does not allow the town to require an owner's affidavit because it's not expressly identified in the statutes. That's their first argument, a summary of it. The town's response to that is that the town did not require anything that is not listed in the statute. Government Code Section 65941.1A13 clearly requires that the applicant either needs to be the property owner and provide contact information, or provide the property owner's consent if they are not the property owner. The applicant advised the town that there were multiple property owners, which we're aware of tonight. The applicant has talked about both he and his wife owning it. And the town requires that all of them comply with the requirements of A13, which means that all are required to sign the application and provide their consent, given that there are multiple owners. That's also consistent with the HCD form, which specifically says that if there are multiple owners of property, that all owners must sign it. The second argument that's made by Yimby Law is that the town acted in bad faith by waiting until HCD certified its housing element to accept the applicant's preliminary application in order to deny potential builders remedy rights. The town does not agree with that statement. The town actually advised the applicant since March 2023, far before the deadline for submission and before the housing element was certified, of the need to provide the owner's affidavit, and also provided the applicant with the applicable forms to be able to provide that information. And so the town has consistently advised of the forms that needed to be completed and the timing, and they've done that long prior to the actual certification of the town's housing element. And so the town doesn't believe that there's been any actions that have been in bad faith. The third argument is that Government Code Section 65941.1D says that the preliminary application doesn't require an affirmative determination by the town regarding completeness, and that the applicant has therefore vested the asserted builder's remedy rights here. Section 65941.1 states that an applicant is deemed to have submitted a preliminary application upon providing all of the statutory information and the payment of all of the fees. The town acted consistent with the statute to review and to advise the applicant that their preliminary application did not provide all of that statutory information. And so the town believes that that argument is also not supported. The next argument that was made in the Yimby Law letter is that the town's actions are in violation of the Housing Accountability Act. The applicant has not actually submitted a formal application under the Housing Accountability Act yet, and the town has not taken any action with respect to the project. As the council recalls, Suzanne spoke to you earlier this evening about this appeal is simply on the preliminary application and whether it's got all of the required components. The town's action tonight is not taking any action on the project itself, so it's not taking any action on the ability of the applicant to be able to try to process the application consistent with the town's housing laws and the Housing Accountability Act. And so those are the primary arguments that were made by Yimby Law. And if you give me just 1 second, I'll flip over to the other one.
Were we sent the other one? I saw the Yimby Law letter in my inbox, but I didn't.
Deborah, can you speak to whether or not the Cal HDF letter was posted?
Yes, it was posted. It's up there now.
All right, thank you. So the second letter was submitted by Cal HDF with regard to the project, and it it too raises a series of arguments, and I won't repeat all of the issues to the extent that they're the same between the two. But one of the arguments is that the ownership affidavit is not required for the preliminary application. And as we indicated before, we believe that under section 65941.1A13, it does require confirmation of the property ownership. So that's similar to the argument, the response to the argument that Yimby Law made. And then the second argument was that the applicant owns the property and provided the contact information itself, so that is sufficient for the preliminary application. We believe that this claim kind of disregards the fact that the applicant is not the only property owner. The property is, as Sasha has indicated, is owned both by himself and his wife in varying percentages. And so again, HCD does require the signature of both. And the last one again is an argument again that the town acted in bad faith, and the information that I provided before is similar to that. The town did in fact provide notice of the requirements repeatedly before the town's housing element was certified. So there was an opportunity for this situation where not all of the correct information had been submitted to be remedied well before the housing element was certified. And with that, Madam Mayor and Council, Claire and I are happy to answer any questions that the council may have.
Thank you, Steve. Any discussion? Do we have do we need a motion then?
Yeah, yes, the council needs to make a motion to either affirm the decision, so deny the appeal and affirm the decision of the Planning Commission, which would itself affirm the determination of the staff, or alternatively, if the council were to override the determination of the Planning Commission, then there's a resolution for that, but for that one, we would recommend that you direct staff to come back with findings, because we prepared findings in support of the denial of the appeal, because that's been the consistent staff position articulated and upheld by the Planning Commission. But if the council were to grant it, we would want to write the additional findings and bring those back to the council. By granted, I mean grant the appeal and overturn the Planning Commission, overturn the staff determination.
Okay, thank you. Can we have a motion?
I would like to move that we affirm the Planning Commission's decision to deny the appeal regarding in section 3A. Sorry, I can't talk.
And I second that.
And Madam Mayor, that's reflected in the resolution that's in the council's packet, and the motion should, the motion.
Okay, as reflected in the resolution in the council packet. All right. Any more discussion, or do you want to call the roll? Call the roll.
I second
Yes,
that.
I have that. Thank you. Councilmember Schmidt?
Yes.
Councilmember Tonka?
Yes.
Councilmember Tyson?
Yes.
Vice Mayor Mock?
Yes.
Mayor Swan?
Yes. All right. It looks like with that, we can adjourn the meeting.